Hi all, I'm Emroween, back with my second ever video, and you're probably wondering why I'm lovingly cradling a bundle of sticks. In property law, the bundle of sticks analogy is commonly used to illustrate the various rights that come with owning property. You own the bundle as a whole, but you also own every individual stick or right that's included inside of it. You can give some away or loan some out, but you still own the bundle. Since copyright is a form of intellectual property, the analogy applies there too. In this video, I'm going to go over all the basics that you as a creator need to know about copyright, including the individual rights that are included in the copyright bundle, how to get a copyright, and more. Again, before we begin, a necessary disclaimer. I am a licensed attorney, but this video is intended for educational purposes only and nothing in it constitutes legal advice. If you're having a copyright problem, I suggest you go to a local attorney, someone who can hear the specific facts of your case. This video is going to be a lot of information, but it's really important, so I hope you'll stay with me till the end. First, we're going to back up a bit and talk about what copyright actually is and what it covers. Under U.S. law, copyright covers original works of authorship fixed in a tangible medium of expression. That's a long definition, so we're going to break it up a bit. First, original works of authorship. That is a very low threshold. Basically, your work only needs to possess a minimal degree of creativity. What is a tangible medium of expression? A tangible medium basically means a medium that's more or less permanent, in which the work can be perceived, reproduced, or communicated. A sound recording, for example, is a tangible medium. But if you had, say, an impromptu speech that was never recorded or written down in any way, that would not be considered to have been fixed in a tangible medium of expression and therefore would not be copyrighted. So going back to our definition, a copyright basically means any creative work that's been written down or recorded in some way. Copyright protections cover things like literary, dramatic, musical, and artistic works. Whether individual characters can be copyrighted is still a legally gray area. It's far too much to cover in this basics video, but if you'd like me to make a separate video on it, let me know in the comments. In trying to figure out what copyright does cover, it's helpful to know what copyright does not cover. First, copyright doesn't cover facts. A great illustration of this is recipes. A recipe on its own wouldn't qualify for copyright protections because it's basically just a list of ingredients and a list of steps. However, if you express facts in a creative and artistic way, that can be copyrighted. Any of you who have looked up a recipe online know that they usually come with paragraphs and paragraphs and paragraphs of irrelevant story before getting to the actual recipe. Those paragraphs are copyrightable because they present the recipe in a unique way. Another thing that can't be copyrighted is ideas. I could go and write a story where, say, the protagonist steps through a closet and enters a magical world because C.S. Lewis doesn't own the idea of characters stepping through mundane fixtures into other worlds. Usually attached to this is something called savoir-faire, which is another thing that can't be copyrighted. Savoir-faire refer to elements, tropes, or themes that are a staple of a particular genre or that flow from a particular idea. For example, most vampire stories are going to contain a character sleeping in a coffin or hypnotizing his victims. A really good illustration of this is the U.S. case Williams v. Crichton. In this case, Williams, a children's book author, sued Crichton, the author of Jurassic Park, alleging that he plagiarized his idea of a dinosaur zoo. Of course, the court ruled that ideas can't be copyrighted, and any similarities between the two books, such as dinosaurs being held back by electric fences, are savoir-faire, or concepts that logically arise from the idea of having a dinosaur zoo. Aside from an electric fence, how else would you hold the dinosaurs back?
I'm simply saying that life finds a way.
And finally, a few more things that don't qualify for copyright protections are titles, names, and slogans. These can, however, qualify for trademark protections, which is another topic for another video. Let's move on to how to get a copyright. It's amazing to me how many people get this one wrong with such confidence always on the internet. Non-lawyers who try to give legal advice on the internet is one of my biggest pet peeves because they're always wrong and they're always missing important nuance. And law is one of those things where if you advise someone incorrectly and then they rely on that advice, Not only are you opening yourself up to a lot of trouble, you could also really be harming the person you tried to advise. So please don't give legal advice on the internet unless you really know what you're talking about. The way to get a copyright in your work is incredibly simple. All you have to do is record the work in a tangible medium. That's it. That's all you have to do. There is no publication requirement and there is no registration requirement. And most of this video is tailored to US law specifically, but this is something that's almost universal. Copyright protections apply automatically as soon as the work is created. You may be saying, but Em, why would anyone ever register their work if it's not necessary? While it may not be necessary to get copyright protections, there are benefits to registering your work. In the US, you can't sue for copyright infringement unless your work is registered. And if you want to sue someone and get statutory damages for it, your work has to be registered before the person you're trying to sue infringed your work. So you can't find out about an infringement, then go register your copyright and sue expecting to get statutory damages. So it's beneficial to you to register your copyright as soon as possible. In the US, it's only $45 to register, and I'll include a handy link in the description below. You're going to need to go to the US Copyright Office registration portal in order to register your copyright. Now, I wish it were as easy as saying, yes, I recommend that you all go register your copyrights right away, but it's not that simple. And for some of you, I don't recommend registering your copyrights. For artists or prolific authors, it's just not practical to register every single work you create at $45 a piece on the off chance that someone's going to infringe your work and you're going to want to sue for it. For those of you who are looking to traditionally publish, your publishing house will probably handle copyright registration for you, so that's not even something you need to worry about. And if you're someone who can't see yourself ever wanting to sue for copyright infringement, then of course there's no need for you to register your copyright. In addition to thinking that you have to register your copyright for copyright protections, another common misconception is that you need to include a copyright notice with your work. We've all seen copyright notices before, usually at the beginning of books. It typically takes the form of the word copyright or the copyright symbol, followed by the author's name and the year of publication. Since 1989, though, this has not been a requirement to get copyright protections. But just like registration, there are benefits to including it anyways. Including a copyright notice along with your work puts the rest of the world on notice that the work is copyrighted and that you are the copyright owner. And seeing that little copyright symbol could deter would-be infringers from stealing your work. A side note to all the artists watching this, we all know that there are art thieves online who try to claim,
well, you put it on the internet, so now I can take it if I want to.
Obviously, by now we know that's not true and that your work was copyrighted as soon as you created it. A popular way of deterring art thieves is by including a watermark on your work. As an extra precautionary measure, you could include that copyright notice within the watermark itself or in the caption of your post. That way they can't possibly claim they didn't know it was copyrighted. I want to talk for a second about the poor man's copyright. This is something that's really popular in writing circles. What you do is you print off your manuscript, date it, mail it to yourself, and then don't open the envelope. The idea here is that if you ever get sued for copyright infringement, or if you have to prove that you own the copyright in your own work, you'll have that envelope to be able to show the court that you wrote this work before a specific date. Legally, though, the poor man's copyright has no effect whatsoever, and it's not a substitute for registering your work. While yes, it can be useful evidence to show a court when your work was created, any writing program that you use, whether it's Word or Scrivener or something else entirely, is going to contain document metadata that effectively does the same thing as the poor man's copyright. So unless you're handwriting your novels, there's not really much benefit to doing this. One more note before moving on to the next section, copyrights last a very long time. This can get kind of complicated legally, but generally, if you're an individual author or creator, your copyright is going to last the span of your life plus 70 years. After that, it goes into the public domain and anyone can use it. Finally, we can get back to our bundle of sticks. Under US law, a copyright includes 6 exclusive rights. It gives you the right to reproduce or make copies. It gives you the right to distribute copies. It gives you the right to make derivative works, which is really important for creators to know. It's basically a work spun off of the original work. Derivative works can include things like translations, adaptations, sequels, and abridgments. Adaptations can include things like comic adaptations, film adaptations, audiobooks, and so on. Copyright also gives you the right to perform your work publicly and display your work publicly. As a copyright owner, not only do you have the right to do these things, you also have the exclusive right to authorize others to do these things. There are two main ways you can do this: assignments and licenses. Assignments are basically when you say, here, take this stick, I don't want it anymore, it's all yours now. You just gave that right away permanently. You no longer have it, and the person you gave it to is now the only person in the world who has that right associated with this copyright. On the other hand, licenses can be divided into exclusive or non-exclusive licenses. An exclusive license is similar to an assignment in that you're saying, here, this right is yours and yours alone now. But you can place limitations on a license. For example, you can limit it to a specific duration, like, here, I give you the right to reproduce my book, but only for 1 year. Or you could say, here, I give you the right to reproduce my book, but only if you print it in a hardcover format with purple pages. A non-exclusive license is similar in that you can place limitations on it, but it's open to more than one person at once. Movie rentals are a good example of this. If you rent a movie from Amazon, you have 48 hours to watch it, but you're not the only person in the world who can watch that movie within those 48 hours. Hi, baby! Now that we know about our 6 rights, let's talk about infringement. Infringement occurs when someone violates those rights without your permission. So what can you do if you find out that your work has been infringed? Unfortunately, there's not a lot that can be done. The first and most popular solution is to file a DMCA takedown. The DMCA, or Digital Millennium Copyright Act, is basically a law giving certain internet providers safety from being liable for copyright infringement if they put certain avenues in place that makes it easy for a copyright holder to report infringement. That's why a lot of popular social media sites like Twitter, Instagram, and Facebook all have ready avenues for submitting copyright complaints. If for some reason a DMCA takedown wouldn't work, and you have a way to message the infringing person directly, you can try sending a cease and desist letter. There are templates for this on the internet, but I obviously have to recommend that you get a lawyer to help you write one. If neither a DMCA takedown request nor a cease and desist help you, your other option is to pursue legal action. However, to be perfectly frank, copyright actions are expensive. Copyright attorneys are very expensive. For creators, especially small or indie creators, a lot of times the cost of bringing legal action isn't worth the reward. I do want to say here as a note that DMCA takedowns and cease and desist letters should be taken very, very seriously. With both of these, you're asserting that in good faith you really, really, really believe that your work has been plagiarized. If you're not 100% certain that your work has been plagiarized, I advise taking a step back and maybe getting a second opinion. It's unfortunately all too common that people abuse DMCA takedowns and cease and desist letters because they don't like a person's work, because it's similar to but not infringing on their own work, or because they just don't like the person in general. If you want an example of what this looks like, I highly recommend checking out Lindsay Ellis's video covering the infamous Omegaverse suit. As another side note, the Omegaverse case is also a really good illustration of what I mentioned before about Same's Affair not being copyrightable. I was actually one of the first people to make a thread about this case on Twitter way before Lindsay Ellis's video came out, and I read through every single court document that was made publicly available at the time. For those of you who don't know already, the case involved plagiarism allegations between 2 Omegaverse books. And if I recall, one of the attorney's arguments was that obviously this isn't plagiarism because all of the story elements that the plaintiff was claiming the defendant copied from her book were just common parts of the Omegaverse genre. For example, dominant alphas and other Omegaverse things. But bottom line, nobody likes the creator who cried plagiarism. Like looking back at the Williams v. Crichton case, you don't say, wow, Williams was totally right and the Jurassic Park author totally stole his idea and nobody should be able to write books about dinosaur zoos ever again.
The kind of control you're attempting is, it's not possible.
Someone stealing your work word for word or line for line is one thing, obviously, but if you just think there are similarities, don't be that person. I just want to touch on one more thing before finishing up, and that's defenses to infringement. As we've already discussed, you have 6 exclusive rights associated with your copyright. However, there are certain situations where someone can take parts of your copyrighted work legally. The most notable defense to infringement is the fair use doctrine. If you don't already know what that is, I'm sure you've at least heard of it. I really don't want to go into it too much here because it could probably take 5 videos of its own, and I have an interesting fair use video already planned regarding how fair use relates to fan works. But for now, just know that while you do have exclusive rights in your work, there are certain limitations in place. That was a lot of information, and I hope you're all still with me. If you are, by now you should have a basic understanding of copyright law. If you want to know more about anything that I covered in this video, please let me know in the comments below. I honestly think that everything I touched on here could have a video all on its own. Don't forget to like this video if you enjoyed it. Going forward, I'm going to be alternating legal ed videos with general writing advice and discussion videos. If that's something you're interested in, then please hit that subscribe button. And I promise that the rest of my legal videos won't be this dense. We just had a lot to cover in a short amount of time. Anyways, I have some great future videos planned for you all, and I hope to see you here next time.